It depends a lot on how it plays out. From the majority's perspective, the sort of concerns underlying the majority's decision were that if former presidents could be prosecuted once they left office, then it would affect their decision making once they were in while they were in office, because they would be worried about future prosecution. And the majority was also concerned about a sort of vicious cycle in which former presidents were prosecuted, and then so other former presidents were prosecuted in retaliation. But certainly the dissenting justices were concerned that this would embolden presidents while they were in office to take action knowing that they couldn't be prosecuted. And certainly right now we have one of the major party candidates for president who has been indicted on dozens of felony charges. And so although we haven't had in our over 200-year history of the United States another president who's been prosecuted after he's left office, there is the concern that if these are the acts that he was prosecuted for when he wasn't clear whether or not he had immunity. Many people are concerned about what former President Trump would do if he became President Trump again, knowing that he couldn't be prosecuted this time.
And, he's made it very clear that this is almost going to be a retribution presidency.
Exactly,
he's made
yes.
no secret of it. And so this is a very dangerous choice for the American people. And as Joe Biden has pointed it out, it sort of really is a blow to American democracy.
And that is exactly what everyone is worried about. Justice Ketanji Brown Jackson, in her dissenting opinion, called it a five-alarm fire for democratic self-governance.
Yeah. Let's talk more about the legal ramifications. How will the issues be distinguished? I mean, the Supreme Court is sort of sent back to the lower courts individual cases. What might be personal versus official? The hush money case, is this going to be thrown out?
So the hush money case, Donald Trump has already indicated that he is going to seek to postpone the sentencing, which had been scheduled for later this month. This is going to be a little bit of a complicated one because the allegations in that case span the time before and after he became president. The charges at the center of that case involve falsifying business records in New York, which I think it would be a tough sell to argue that that is the official act of a president. And that was the line that the Supreme Court drew, was between a president's official act and a president's unofficial acts. However, I've seen a little bit of reporting about this, and it seems like one of the things that the former president is pointing to is that in securing his convictions in that case, prosecutors relied on testimony by Hope Hicks, one of the president's aides. And the Supreme Court, in its decision yesterday, said that prosecutors can't even use evidence about a president's official acts, not to convict him for those acts, but to convict him for his unofficial acts. And so that may be where the former president is going in the hush money case.
What does it mean for his other legal battles, particularly the one surrounding the January the 6th riots incitement case?
So I think the immediate effect for the January 6th case is just going to be additional delay. This case was scheduled to go to trial on March 4th of this year, and it was pushed back because of the Supreme Court's decision to take up the immunity question. Now the case is going to have to go back to the lower courts. And the Supreme Court indicated that the district judge in that case, the trial judge, Tanya Chutkan, is really going to have to take a very fact-intensive analysis of some of the allegations to determine whether or not the president was acting in his official capacity, or whether or not, as Jack Smith alleges, these were in fact private acts. Something like making phone calls to state officials to try to get them to change electoral votes. Is that presidential or is it not presidential? And so that is simply going to take quite a bit of time. And I think it is extremely unlikely, everyone agrees, that even if Judge Chutkan determines that there were private acts involved and some of these charges can still go forward, that anything is going to happen before the November elections. And of course, if Trump were to be reelected, the charges could be dropped altogether.
Yeah. There are other rulings the Supreme Court has handed down. There have been sort of one a day, or virtually, or a couple a day. One quite interesting that goes to the heart of the power of executive agencies. Now, this is another thing that Donald Trump has been declaring war on. This ruling could really endanger countless regulations. How has this been seen legally in terms of the attack on executive power?
It's something that's a little bit harder, I think, for the American public to grasp, and it's something that the effect that we may not see in our everyday lives immediately, the way that the public has been able to sort of grasp the significance of some of the Supreme Court's rulings on issues like abortion or affirmative action in college admissions. But it is an incredibly significant decision in the sense that it will change the way that administrative agencies can interpret federal laws that they administer. And then when there are challenges to these regulations, up until this week, when federal courts reviewed challenges to those regulations, federal courts were supposed to defer to the agency's interpretations unless they were unreasonable. The idea was that the agencies had often the technical and scientific expertise. If you were talking about the safety of a particular drug or environmental laws, and the Supreme Court said, actually, no, federal courts are the ones who are supposed to determine what those laws mean. And so the dissenting justices in that case, and again, it was the court's liberal justices who dissented, said this is really going to be a seismic shift in how our federal government operates.
Yeah. Amy, when you're sitting from afar looking at your system, there seems to be incredible flaws in political appointments to the Supreme Court. I mean, we're seeing, as you see, these very almost partisan appointments. It seems as if the control of the Supreme Court is now going, politically, is now going much, much further than was ever intended.
Yeah, this is, I've been covering the Supreme Court now for a little over 20 years. And from the Supreme Court's recent history, there were justices on the Supreme Court who didn't always vote in the same way as the president that appointed them. And so you had swing justices, we called them, justices like Anthony Kennedy and Sandra Day O'Connor, who often would join the court's liberal justices on issues like abortion or same-sex marriage. And then you had some justices like John Paul Stevens and David Souter, who were appointed by Republican justices and became part of the court's liberal bloc. And, the court is very divided right now. 6-3. This was, 3 of the justices were appointed by Donald Trump, and he really saw the Supreme Court as an issue that could help to get him elected. He set out to, he published a list during the campaign of justices that he would appoint if he were elected. And I think it gave conservatives a lot of comfort that they could vote for him. The Supreme Court has been an issue for Republicans for a long time in a way that it hasn't been for Democrats. And I think right now you saw this with the President Joe Biden last night in his press conference, are going to try to use the Supreme Court as a rallying cry in the 2024 election. The problem for the Democrats is that the current composition of the Supreme Court is fixed and is going to be hard to change for the foreseeable future.
Indeed. Amy, appreciate you helping us make sense of it all. Thank you so much.
Thanks so much for having me on.